Good afternoon, everyone. I am Allison Mata, and I am currently hosting Defense Diaries podcast. Um, so it's been like a long couple days, obviously, with me doing more uh, coverage with Bob and more YouTube with Bob, and my regular work. I am not sleeping well, so I don't tell me I look tired today because I am tired today. um, so I've spoke to Bob. They've had some issues in the courtroom. Uh, The the defense was trying to put on some video, stuff like that, camera footage. They argued to keep um, the audio out because it's hearsay. Bob couldn't hear what objections were raised because it was done at a sidebar. There are, like, numerous exceptions to hearsay, and those of you who think and I understand it seems like what Gull said yesterday, like, or somebody said in court that he could call his client to the stand to get in that phone call. If something is inadmissible, for example, a self-serving hearsay statement, getting on the stand doesn't change that. Getting on the stand would change, well, before that, before I said all of that, I had already, you know, felt like I was going crazy. I'd even conveyed that to my family, like him describing it, not getting on the the recording, unless it's subject to an exception to the hearsay rule, which it is here. It is under the rule of completeness, and it is under several other exceptions, you know, especially state of mind being the very easiest one and obvious one. But the judge isn't seeing it that way. But if the judge is not seeing it that way, and the judge is saying this is hearsay, him getting on the stand does not change that it is hearsay. So, and if having a party to the conversation on the stand would change it, they could just as easily call the father. He was a party to the conversation as well. So, there's I don't know what Judge Gull is thinking. I can only tell you what the law is, and um, so circling back to where they were today, so first they wanted all the audio off so they could only watch what was going on, and then apparently there was some issue with the dates and the time frame of the recordings because different parts of discovery gave the dates, and the person on the stand had to explain to the judge, like, how did you determine the dates? So the judge wanted the witness, and that's I think Max, maybe a guy that works, an intern at one of the defense lawyers firm, or with one of the defense lawyers, or with the team. I don't know if he's just interning on this specifically. I had to go back and pull everything so that they could show to Judge Gull, here's how we know the dates of each of these recordings, instead of the witness just saying it. So because of that, they kind of went out of order, and Bob's suspecting they might end early today. The judge didn't want to hold things up, so they said for them to go back and work on that while they took another witness. So, let me start with where we started today. Um, I'm gonna try and see if blowing it up on my computer is better than reading it with the glasses on paper. So, see how this works. All right, so they called first is Christopher Guti or Ruti. So Bob wanted me I was looking at his notes. He says, "Babe, discuss difficulty of directing a cop." Um, so obviously, when you're typically a defense lawyer is cross-examining a cop, much easier. You say whatever you want to say, and then you say yes, and then you know, show them things. But when you're calling somebody on direct, you can't suggest the answers. You have to ask an open-ended question and just hope the witness provides the actual answer. So it is exceptionally difficult. They are, as I'm sure you've all heard many people refer to them as, um, expert witnesses. Um, so they know how not to answer a question. And a very dirty dirty trick that the prosecution pulls not only with their cops, but with regular witnesses too. And you see it played out here in real time. There are no ifs, ands, or buts about what McClellan did here and how he planned to do it before this witness got on the stand. Um, and that dirty trick is if they show you something to refresh your recollection, you just say, "No, it doesn't refresh my recollection," and, "No, it won't refresh my recollection." But you can see how it plays out here, and you'll be able to see how this was planned and a clear sabotage and stonewalling. But Bob wasn't sure if it's something that the jury would see as clearly and evidently as, lawyers who are watching. So, all right, he is a Hammond he works at the Hammond Police Department. He was partnered up with a federal agent. I didn't give his name later. Talk about how he went to high school, some college, the Indiana Law Enforcement Academy. He did some training. What is his training? Interviewing suspects. He went to Reed School. Okay, and all he would say about that is it's a technique to interview people. Um, and he's asked about when they document interviews, what is it important uh, to include what they say. Um, Important to include everything that was said accurately. He agrees with that. He worked on the task force. All right. So, did you work with Adam Poole? And that's an FBI agent. Yes. Did you work on the murders of Abby and Libby? Yes. Did canvassing and interviews? Were you partnered with Agent Poole? Yes. How many interviews did you conduct? I don't know. How long were you working on the Delphi case? A couple of weeks. Did you speak to a Bradley Weber? Yes. So then there's uh, some kind of objection, I think, that they were anticipating. It's in parentheticals. So what I can't tell here is this Bob's note or was it what was said in court? So we'll have to ask him because he wrote prior inconsistent statement being used for impeachment, not substantive. Now, first of all, if Bob wrote this is which is what I'm possibly thinking because he's assuming that this guy either authored the report or signed the report, but as we're gonna see later, he didn't. So if the defense team I can't imagine that the defense team called it a prior, inconsistent inconsistent statement. Um But anyway, the next question is, where did he go after work? Home. Are you familiar with FBI 302? And he says, yes, it is. And that's just a report that the FBI uses basically anytime they're making a report, there are 302s. Yes, it is. Can I reflect your recollection? She shows it to him. This is O'Shea uh, doing this direct. And he says, yes, his recollection is refreshed. And then McClellan chimes in. Okay, here you go. McClellan chimes in. He wants to do those preliminary questions that we've been seeing them do, a mini voir dire. So he says, did you write that report? No. After reading it, did it refresh your recollection? And the answer was yes. And I can guarantee you when you see at where we go from here, that wasn't what he was supposed to answer. But the mere fact that he asked the question after reading it, did it refresh your recollection, shows that he was expecting this witness to say no. Um, so then it goes back to questioning because, all right, he said his uh, recollection was refreshed. When did you speak with Weber? February 13th, 2017. Did he so did he go anywhere else before he went home? I don't know. Okay. Then she says, you just read the report. Didn't it refresh your recollection? No. I mean, are you kidding me? Are you kidding me? So here's what I asked Bob about this because, and this could just be, there's some foundation that we as attorneys lay that Bob might not think as it's being said warrants going into your notes. It's just like, is this a proper? Does it properly? Is this a proper? Or have you seen this before? Does it properly reflect what we say it is? Like things like that. Because I asked him, I said, okay, did she ask him before she asked the next question? Is that is that the report? Yes. Have you seen it before? Yes. Does it fairly and accurately represent what was said to you during that? And if he answered yes, okay, then we ask if it refreshes his recollection. Now, when he says no, because that's what I asked Bob. Well, when he said no, did she try to impeach him? He said, if it's not in my notes, I don't think she did it. So if she didn't ask those questions, then that was, I think that she should have, because if he would have said, yes, it properly reflects my recollection of everything, and then she could have actually impeached him with it instead of just using it to refresh his recollection. Meaning, okay, but, you know, and then she could have asked to treat him as a hostile witness if he's literally saying, yeah, he reads it and it says, obviously, that he did not go right home. It says where he went. He says it refreshes, yeah, the witness says it refreshes his recollection. And then the witness says, I don't know if he went home or if he stopped anywhere beforehand. But didn't you just say your recollection was refreshed? No, so then she could have impeached him and literally got what he said in, that this is the words that were spoken. Didn't you just say that this accurately reflects your recollection? Yes. And in here, it does say he went to stop for ATMs, whatever it says. She could have also tried something like, well, okay, I'm going to let you look at it again so you can read it more fully. And you let us know, you know, when your recollection is refreshed or something. She could have maybe highlighted that he was being obstinate and, you know, so that the jury could have seen exactly what was going on there. But, it's not a typical question to ask somebody. Oh, but did it refresh your recollection? Because clearly it refreshed his recollection. He read it, he knows. They do this all the time. That might have been something else I asked, like, how often do you testify? And when's the last time you testified? And when you do that, are you often, talking about reports that are years later? Yeah, and when's the last time the state handed you a um, a report to refresh your recollection, after which you looked at it and claimed your recollection wasn't refreshed. Have you ever done that? What case was that in? I don't know, stuff like that to kinda highlight it so the jury could see what was going on just in case they missed it. I tend to think they didn't miss it because they've been so on the ball, but we're gonna have to talk about some of the jury questions that come with the next witness. So I do not think there were any questions here. I don't know if they were kinda taken off guard because that the way that that happened. But now, in response to this, the defense have subpoenaed or indicated that they are calling Agent Poole. There was a motion filed today that just sought for permission for Agent Poole to testify remotely via Zoom, however it is they do in this courthouse. Now, the federal agent didn't have to agree. I'm assuming since they are asking for him to appear telephonically, that they've spoken with them, and the agent's like, "Sure, I'll testify." Otherwise, what they would have to do is file a special motion and establish that there's no other way to get this evidence. And this guy just gave them that because he just stood up there and said, "No, my recollection's still not refreshed." So they've got no other source to get this information other than Agent Poole. So Bob was thinking, that the defense didn't seem all that surprised that this guy was an obstinate jagoff who, just blatantly lied. I mean, I'm thinking people need to start reaching out to the Indiana State Police and saying, "Do you know your agent just committed perjury? Like, is this something that you let your agents do?" I mean, obviously, we can't prove that it refreshed his recollection, right? You can say, "Well, yeah, I read the words, but it doesn't trigger my independent recollection." So it's not like, but every cop, everybody can see, they know what he did, they know what he was doing, but technically it's not really perjury. It's not really, um, like a violation that they can prove, but even his supervisors will know that was dirty pool. Obviously, he read it. He said his recollection was refreshed after reading it and then denied that he knew what it said. So, um So, in any event, Bob was thinking that the defense didn't seem surprised when he claimed that his recollection was not refreshed. So, that he thought, that they were likely putting him on, A, either hoping he's going to tell the truth, but B, if he denies it and says he still doesn't know, like he did here, it opens the door for them under TUI to um, require the FBI to provide the information through their witness. So he gave them that opportunity where maybe they would not have had it before. Let me just see if you guys are saying anything over here. Um, Thanks, Jessica. Off topic, but voting is here. Uh, Gull's conduct makes voting seem extra important, but it's hard to know about local judges. Any thoughts? I don't know when she's up or if she's up. Um, but um, I think that it's something that everybody skips. This is my opinion. I think it's something everyone skips unless they're like, you're going to have way more people who have been at fundraisers and events for a judge who's on the ballot than you are going to have the occasional super pissed off citizen who realizes a judge is up for election and then goes in and votes for them not to maintain their position. But it's on the ballots in my county. Our judges hit the ballots, and but I honestly think it's something most voters don't even look at. But yes, voting is your superpower, all of our superpower. Do it. I don't care what it is, and I'm not asking for anybody's vote, but you know, have your say. have your say. Um, and so Free Richard Allen or Dave says, I so here's the thing, I think it is, but again, all right, technically, no one can say that this guy's recollection was refreshed because you could show me a piece of paper and this is legit with me for sure. You could probably even show me a picture and I'm gonna be like, "Yeah, but I have 0 actual independent that did not trigger the memory. I see that it happened. I see that I wrote that. I see that I did that, but I have no recollection." But every cop and their mother knows that every time a cop is shown a police report, they're saying their recollection was refreshed. They know that that was intentional, that if he wanted to be, honest, he would have just told the truth, but that they know that that's a ploy, although it's not something you can prove. Like, I don't think it could really technically violate the moralities clause because they can't prove that he just it's been years since then. I've interviewed tons of people. I don't remember what the guy said to me. And that's probably true in all of the times where they're testifying that they remember everything. "Oh, yeah, I did this, I did that," and it's like, 7 years later, "Oh, you just remember all that." "Oh, yeah, I reviewed my police reports and I remember." No, they don't. They just remember what's written in the police report. So all I'm saying is that everybody will know, all right, that clearly like that was a bullshit move, and maybe someone will be upset, but maybe not, maybe not. Maybe nobody will give a shit, but, um, so yeah, what Jenny said. It's in the report, it happened, and this guy is, gonna say his recollection's refreshed, like, "Oops, shit." That's what I usually say when I'm asked this question. I was supposed to say no, um, and I guess we'll just have to wait and see if anyone else has, uh, any other notes about if the defense laid any further foundation, like I said, such as before even taking the report back, does it truly and accurately represent what you remember happening that day? And if he says yes, it does, while he's yesing things, before he gets reminded, you're supposed to say no, you know, then he's locked in. But I do not blame the lawyer for that if she didn't, because I've been there and you cannot think of every possible thing while you're like standing and things are happening. Trial is fluid. You don't anticipate someone to say their recollection is refreshed and then say it's not in the next breath, and then still deny it. Um, so I mean, seriously, but what pisses me off, what I just can't stand is the judge knows. The judge knows. I would have been like, "Your Honor, can you instruct the witness to answer?" You know, technically, again, she can't get in his mind and know his recollection is refreshed, but we've seen it in these other trials. We've seen it in YSL. We've seen it in Baldwin where judges get pissed off when they see the game the prosecution is playing, when they see the game the state's witnesses are playing. Like, it's supposed to not be a game. It's supposed to be a search for the truth, and I would expect the judge to get pissed. First of all, okay, first of all, I don't understand, and again, we're not there for these sidebars. But when they put on the witness, the last witness they called, whoever it was, to testify that he went out and interviewed, um, that he went out and interviewed Bradley Weber, right? And that he read that report, right? The report, the 302. He testified. He said something like, "Well, I hadn't read it earlier, but I did read it today." And then he testified that he went straight home. He could be impeached, either his credibility okay, or his actual testimony that this guy went straight home or that he believed he would have been home at this time, any of those things, with the fact that, okay, you said you have no reason to doubt that. You think it's credible, but you're aware he made an inconsistent statement before. And you said you read this report, and that report did not have him coming straight home. How the judge wasn't allowing that as impeachment or reprimanding the state. Like, if that is true and you're putting this officer up here to say the guy went straight home when there's another officer you didn't call who said the guy did something else, I'm not going to have that shit in my courtroom. I mean, the prosecutor is not supposed to be playing tricks and games, and I just don't know why they're not being reprimanded by the judge, why the judge doesn't get pissed off. And this isn't the first time this has happened. This has happened to me in so many cases where I'm like, shouldn't you be getting pissed off? I'm telling you that they are misleading you. And here's all the proof that they are. And, I would get infuriated even then. Like, and I've told this story a bunch of times and I'm going to just tell it again, so you guys can see a really good example. We had a case where the cop took the stand and I started challenging him on whether or not the uh, a witness that he interviewed had his father was present for this interview. And he kept saying, "No, we don't even do interviews at this spot." Um, and it was a huge point, okay? And they were trying to uh, basically say something happened that didn't happen, and I don't not gonna get into all the details. So the cop gets off the stand. I call the kid's father uh, as my witness, right? So the judge says to me, "Are you about to call this guy and try and tell me that that cop who I've known for 20 years just perjured himself?" And I was like, "Well, it's gonna to impeach the cop, yes." And he yelled and screamed at me, and this is a situation where the courtroom sometimes at trials, like, the courtroom's full with people watching. So this was one of those times where other lawyers were in watching. So he's yelling at me about how if I can't prove to him that cop lied, he is going to report me to the disciplinary commission. He's gonna rah, da, 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 like yelling at me. Okay. And then, as an aside, he looks over at the prosecution. And if she does prove it to me, I'm going to report like the elected state's attorney. Okay. So but we take a break and he says, "Do you still wanna do this?" Like, "Arr," expecting me to be like, no, I feel like maybe I can't." And I'm like, yes, Your Honor, I have every intention on doing exactly that." So he takes a break and I'm sending my this part of the story doesn't matter. But at the end of the day, the the prosecution, knowing I was about to prove this, found found the, Miranda waiver, and on the Miranda waiver, it says who is present, okay? So it proves it took place that this kid was that was the whole thing, that they said they never even interviewed this guy. So that they interviewed him, his father was there, it was done at the place that I said, and so at the end of the trial, after we got after they got found not guilty. In an empty courtroom, the judge tells Bob and I that we're a credit to the defense bar and there should be more lawyers like us. But this judge was actually a former defense attorney and he was not going like it wasn't like he was just being a jerk. In his heart of hearts at that moment, he thought there was no way in hell that all of this stuff that they were presenting was bullshit. He just didn't believe it. Like it's just they're just so programmed to believe the state, to believe the police. It's not only the public. And I've been having this issue in Chicago. In Chicago, we have all this corruption that came to light. these officers, if you watched the series, now I'm gonna blank on the name, and if Bob was here, obviously he'd know by me just saying the word series, but, was it Boston? Was it, like the cops with the drugs and I do that, and Bob knows exactly what I'm talking about at all times. Um, but I can't think of it. But it's, like that situation where the cops are arresting the opposite drug dealers or rival gang members because that gang's paying them. Um, and they had like the scripted version, and then they did like a documentary version where they used the real police officers' names and all of that. Yeah, it's in Baltimore. Somebody that's right, it is in Baltimore. It's the one in Baltimore. Um, so in any event, all that whole story was for the fact that th I'm not saying that Judge Gull, knows they're lying and, it's just sh hard she probably just hasn't accepted it, The Wire, yes, and then there was We Own This City. You guys are on it. Thank you, Andrew Brown, and we got, Jenny and Tiff with The Wire. Yes, yes. I mean, Bob would have had that in 30 seconds. Um, so I'm honestly just saying, I can see how the judge because people get stuck in their ways. It's not just the public, how the judge is just thinking, because I had that issue with that judge had followed from another case where he again just assumed that we were arguing that our client had a mental illness and that stuff had come to light that we needed to push the trial, and the judge thought we were just making that up to get the trial pushed. The same judge, he now holds me in high regard, I think, and realized that his own internal, biases, and that's even for a defense lawyer. But to see this transpire, to see it so black and so white and so in your face of this cop looking at his report, looking at the report of the interview of Brad Weber and saying, ask the question, "Do you know if he went straight home?" You know, and he says he went straight home. Well, would it didn't he go somewhere else? Not that I know of. It's going to refresh your recollection. Look at the report. He looks at the report. He reads it. Where in that report it says exactly what this guy did before he went home. I don't know what it is. What we've heard, I guess, is that he worked on some ATMs. And he says, my recollection is refreshed. And then he's asked by McClelland, is your recollection refreshed? On wadeering him, hoping his answer is gonna be no, and he says again, "Yes." And then when he's asked again, "Okay, so where did he go before he went home?" He says, "I don't know." Wait a minute. The judge sees that. There is no denying that. It's what needs to happen? What needs to happen? And sometimes it's just got to be that black and white documented Miranda warning that proves everything, going back to my example, that proves it all before the judge is like, "Oh my god." And even with all that corruption in Chicago and the judges starting to realize how much it's just in again and again and again with the lies, people getting, released from prison, people getting millions and multi-million dollar settlements, but sometimes the judges still aren't willing to accept that somebody framed somebody, somebody planted something, a cop's lying, and it's got to change. It's got to change. So, I'm sorry for now I'm the ranter, um, but that's the first witness, and I hope the jury saw it, but I I also know how hard it is for people to see things sometimes. So, then we move on to, and again, like I explained, this is where they wanted to call their intern to go over all the recordings from the prison, from the jail, from everywhere, but they had to put it off. So they called Dr. Deanna Wagner. She is a doctor of psychology. She works with the IDOC. She worked with the state. She was employed by Centrum. Um, and they supply IDOC with psychologists. She knows Richard Allen. She oversaw Monica Walla's treatment of Richard Allen along with Dr. Karras. And she said that they oversaw him together. Um, are you familiar with where Richard Allen was housed in WCU at Westville? Yes. Was he transferred to Wabash? And yes, and he was in a similar unit at Wabash. Then she was asked, "Did you play a role in Richard Allen being transferred?" No. "Do you know why he was transferred?" No. And then there's a note here, like, I'm not exactly sure how this came out, but about Newcastle having an acute unit. So I don't know if I think what was discussed here was like there's these other places that have units that deal with people with mental health issues. So then she's asked, "Did Dr. Walla advise you she had an interest in Richard Allen's case?" And the answer was, "She told me about it after treatment began in early of 2022. She told me about the case." Now, this is crazy. This looks like it's all still in the answer according to these notes, but it says recommended same pod close to something to listen and to learn more about the case. She recommended a certain pod or the same pod or some pod close to something to listen to and learn more. Oh, no. God, guys, sorry. She recommended some podcasts to listen to learn more about the case. All right. Sorry. I was like, this is outrageous. She told her that she specifically had Richard Allen in a certain pod so she could listen to things. All right. Rewind, strike that from the record. She recommended some podcasts to listen to learn more about the case. My bad, guys. Did she ever tell you she visited the crime scene? Yes, she told me she did before, and then I can't tell if it was before she got the case. It looks like a question, like, was it before she got the case? Or no, she did not know if it was before she got the case. Okay. So, is that unusual? It's somewhat unusual. Do you know Dr. Martin? Yes. What is his role? He would administer medication and injections. Talked about the RDC evaluation that's supposed to occur at the time you get arrested. He was only there for a day. Usually people are there for a couple of weeks. So then it looks like mm, some either some exhibits got in or Bob was just like, I think maybe he was numbering the things they touched, like his medication, his mental health diagnosis, the benefit from individualized therapy, institutional. And Dizzy or Mandy, if you've got any more input on what that is discussing, let me know. Um, did you do a competency restoration? No. They would typically be sent to Newcastle for that. Do you typically deal with safekeepers in Westville? Nope, we don't. Was he being threatened by other inmates? Yes. Do you know he had cameras 24/7? Yes. Did you request that cameras be removed? Now there's no answer here, but I'm going to assume yes because the next question was it removed? And the answer was no. Did you view any of the movement or video any of his movements or videos um in the cell? No. So, long-term effects of solitary confinement, she says there are 2 schools of thought. Bob didn't write what they both were. Um, there are 2 somethings of thought. It doesn't say schools. I'm saying schools because I can't figure out what that word is, but it's definitely not schools. Anyway, is there a 30-day rule if seriously mentally ill? And she said that that only applies if the inmate has a serious mental illness. Um, being a safekeeper doesn't necessarily mean that solitary is going to be more helpful. And she agrees with that. Um, then they talk about what the primary goal of mental from a mental health perspective is, um, which I can't 100% make out, so I apologize. Um, is it possible that long-term segregation can cause additional damage to mental health? Yes. Mental health monitoring in restrictive movement is not ideal, and it's not therapeutic. So, then they talk about they're building a new prison that she's excited about because it will be have better treatment facilities. Um, there was some objections, about relevance. Goal, let's keep it to this. Alright, not exactly sure. Um, are you aware of his treatment protocol? Yes. If he was on suicide watch, daily visits. Was he receiving daily visits? Yes. And that's where Gull said keep it to it must be like the facility because that's where the arrow goes and there's some objections. You would agree that solitary confinement can never be conducive to treatment. Yes. Okay. It's toxic to their welfare. Yes. Does the IDOC have a placement policy? And then so they talk about that there's Newcastle, Pendant something, Wabash, um, and it's got Wabash on the lowest treatment level, as far as ability to treat mental health. Then it goes to Cross. When Richard Allen came to Westville, were you familiar with his RDC evaluation? She said, yes, and he was not deemed seriously mentally ill. When did they classify him as seriously mentally ill? After he received, I think, some sort of diagnosis, probably the psychotic diagnosis. Who contacted you in April? Walla. She was advocating for their visits. Now, clearly, the state wants to get this in to show Walla was advocating for him. And I don't know, maybe she was, but it could also be seen as she was advocating for him to get family visits because now he had confessed. When did a multidisciplinary meeting occur? And she says, when Walla had questions about whether RA was feigning his psychosis. He that was a at that point he did have a significant mental illness, a grave disability. Um, and what are the symptoms of psychosis? Not eating, not caring for yourself, not working. They ask what feigning is, or talk about how whether he was choosing not to eat or care for himself, or it was due to his psychosis, he still has to be he still has to be treated because he's having the same, the same symptoms. So it's just whether it was a result of his psychosis or what it was a result of his um, strategic decision, I guess. Haldol is used to treat that psychosis. Yes. So now we're on redirect. When when was Richard Allen classified as significantly mentally ill? April 2023. Did the classification into the system result was it as a result of diagnosis back in 2012? Yes. And did the classification system arise as a result of a diagnosis back in 2012? Yes. Objection. Sidebar. Is major depression disorder considered to be an SMI? No. So I don't know. I guess we'll need to find out what else was in the 2012 um, diagnosis, because she answered yes to did the classification system arise as a result of it looks like diagnosis, but it says something back in 2012. So maybe there's something else there. Um, all right, jury questions. So I don't know. You guys are gonna have to tell me what you think about this before we get to jury questions. Let me see what y'all are saying. Thanks, cool lady. She gifted 5 memberships. I forgot to ask Allie and Carol last night if the jury instruction on voluntariness of a confession in Indiana. I was actually gonna go look at their jury instructions. I wish you would have thought of it yesterday, Travis. Um, I mean, Emily asks if he's acquitted, can he sue for cruel and unusual punishment? Um, he can definitely sue for a civil rights violation, arguing he received cruel and unusual punishment. It's just like the so yes, yeah, it would be a civil rights violation. Um, and it sounds like this evidence has basically demonstrated all of the elements for that, but I don't know for sure. I'd have to look at it specifically. Um, but to me, because there was just some contradictory answers there about whether or not he did have when he had a serious mental illness and what it was triggered by, but they didn't change it after he got that diagnosis. But I think, if you remember the what's the word they gave it? Like a limited psychosis. I can't think of it right now. That's when it only lasts 30 days, and that's the thing, you can't keep somebody who has a serious mental illness more than 30 days, but we can tell this went on, and he was getting treatment well beyond the 30 days, but then she said, "Well, it can come and it can go." So this is all I'm saying, this does not seem like Walla was doing any favors for Richard Allen. She clearly, even if she thought he wasn't guilty, even if she questioned his guilt, I don't know what her position was, but she wasn't doing him any favors because all she needed to do is not call it temporary. I think that's what it was, like temporary psychosis. See if anyone in the chat is remembering what exactly the diagnosis was. Brief, thank you, 2022 tantrums or 22 tantrums, brief psychotic disorder, just a reoccurring brief psychotic disorder. So, you know, does that get them over like the 30 days? You can only house them like that for 30 days. So if this psychologist was trying to do him any favors, if that's someone's position, like, oh, she was on his side, she's trying to help. She wouldn't put words in his mouth. She wouldn't say things that help the state or help the, police or the prosecution. She's not getting any pressure from any of these agencies. She's not their whole entire lifeboat. He's You're the only one that can talk to him, get us what we need. If that's not what's happening, why is she giving him brief psychotic disorder? Why is she waiting until a month after she says it started to give him that diagnosis, instead of just saying it's a psychotic disorder so that he had to get out of there in 30 days. If she wanted to help him, that would have forced their hands to get them out of solitary like that. But that's not what she did. She specifically, the way I see it, in my opinion, that this evidence demonstrates to me that she was specifically trying to, like, not say that. The fact that she called it brief, she did it so far after the fact, and then she starts to say, "Wait, maybe it's feigning," so that they don't have to take him out of there, maybe he doesn't need this classification. Wait a minute, you know? Um, I think that there was probably a lot of pressure. It sounds like she still works for the same company. She's still in other prisons. She probably doesn't wanna lose her job altogether. She already had to move out of state. She's already lost, the position she had at that, facility. So, um, now defense attorney Meow asks, "Is the diagnosis within her scope?" Yeah, that's my understanding, unless I'm wrong, and then the psychiatrist, I think, provides treatment based on the psychologist's diagnosis. What we do know for sure from the evidence admitted during this trial is on May 3rd, it was either the 2nd or the 3rd. I don't have it literally right in front of me, but I'm certain that it was one of those 2 where she did her addendum, where she writes his diagnosis and calls it a brief psychotic disorder, which 22 tantrums just, um, reminded me. So, let's just go back here. Tear Talk from Prison to True Crime. Thank you. Oh, I'm going to cover the truth about solitary confinement later tonight and that the system is being attacked in a way to negate confessions. Um, and I'm going to come back to all these. I was just looking for questions. But this crime time croquet, thank you. Comments right on point with what we're talking about. They said she was advocating for their visit. Sounds to me like she was trying to get more time with Richard Allen. I mean, uh, that's this that's a lot of what I'm seeing here too. She's going out of her way to, you know, to spend more time with him and at least make him think that she's an advocate, you know, whether she's listening to the podcast and all this information thinking this guy's guilty as sin, but saying to him, there's a lot of people out there who support you. Doesn't change what her mental state might be. It doesn't change what her actual motivation is. It doesn't tell us what her motivation is. It only tells us what she was saying, which, according to her own words, she could have been saying those things to him for secondary gain to get his trust and then use it against him. And that's just my opinion, obviously. So, and it's just one possible. That's the point. It's just one possible interpretation. But it when you've got two possible interpretations, that's reasonable doubt. That's reason to doubt her motivations. Okay, so let's go to jury questions. I don't know how I feel about them all. I haven't read them all, but um if detainees under safekeeping order are kept in general population, so the question is, if you know, does the DOC ever place safekeepers in general population? Answer: yes. Question: Couldn't it be possible that now, right there, I'm obviously not back behind the TV with the white noise on, talking, making assertions, but that is clearly, could it be possible that speculation, okay? Speculation. The but I'll finish the question. Could it be possible that objection, speculation, lack of foundation, Mr. Allen was faking symptoms in order to not be moved to Gen Pop due to fear of being harmed? So that's a question that shows there are some jurors giving him more reasons of why he was faking his symptoms, coming up with more reasons of why it was fake. So I'd say that's strongly in the prosecution side question. Someone wants to start keeping tabs. Did you ever actually hear anyone making threats to Richard Allen? That's also s- strongly on the prosecution's side. Answer no. Another one that I think is strongly on the prosecution side. Don't know if these are all the same juror. Maybe Bob can tell us. Put it in your minds to ask him tonight. I don't know that I will be here. I've got Scarlett's got batting practice and then volleyball and a lot of household stuff has to get done. So the next question, oh, you need the answer, right? Um, so the answer was no. All right. So the next question, whether faking or not, okay, whether faking their symptoms or not, is it possible for a person to slip truths in a confession? So that's squarely on the prosecution side. I don't care if he's faking or not. Sounds like he slipped some truths in there, you know? Like, and she says she's seen it both ways. Seen that confess to things they have done and to things that they haven't done. And it was hard to tell. So, all right. Now get another question. Um, I don't know. Um, Let me see. So that's it's talking about brief psychotic disorder. You're detached from reality. If feigning, um, to tell more of a story. I don't, is there organization to the story? Full, deferential, directed? I don't know, guys. I can't make it out. Um, so I can't make it out. Uh, is the confession related? Persecutory, hypersexuality, hyper-religiousness, and then 2 other things, kinda themes. So, I don't know if this is all still jury questions because there's so much more uh, or if this is I mean, obviously, they all ask questions afterwards, so this is getting harder for me here. So, he wasn't psychotic 24/7. You can slip out of psycho in and out of psychosis. Um, Conversation points can ping psychosis. If what they are rooted in logic, linear, made sense. I don't know. Uh, Richard Allen was assessed with delirium, and then it said I think that was a question, was he? He did not have, is all. I think Bob was having a real hard time getting these guys, so we'll have to have him go over, and then, like, what's the typical protocol for safekeepers with significant, uh, mental illness or serious mental illness? And then it says that it was the same for general population. But technically, it's not because you have to be put in general population or, you can't stay in segregation. Um, but the question was, what would the typical protocol be? And then the question was, what would oh, and then if it would be the same, procedure post adjudication. And she's saying it would be the same post adjudication, meaning if the person was in prison after they were found, uh, after they were found guilty, and, then, like, about the primary concern, um, primary responsibility what was the primary responsibility of the DOC for safekeeping people with, serious mental illness, and it said safety was the primary concern. But then you've got, um oh, maybe they did actually call, unless this is where they broke. So, because this has them calling Max. So, they discussed case management, called the next witness. There was no jury in the room. This went on for a while, Bob told me. Then they called this Baker, who is the intern. Did you hear Harshman's testimony yesterday? Yes, 7 hours of audio, you know, and then did I ask you to identify a couple of videos that could demonstrate his mental state? Yes. And how did we acquire the videos? In discovery from the state. What are the 2 types of videos? Camcorder with audio and video, and in-cell with video only. So the in-cell has no sound, and the camcorders, whenever he would move, where they would follow him and there would be sound. Um, were we accusing anyone of tampering with the videos? No. What's the time frame of the videos? So the camcorder videos do not have dates and times. He tries to say it's November 2022 to December 2023 on the camcorder. How are you going to put time frames on the video on when the videos are framed chronologically? Something like that. Use the reports and the transcripts to try to match up things we were seeing. So this is why I think they started having issues to match up the things we were seeing and what we read and what we heard on various reports. Um, and then they had I can't tell if this says lengthy or intensely something, a sidebar. They put in some exhibits, the thumb drive of the camcorder videos from Incel, the sheet detailed with the date of cell videos used, as well as the time of day for the condensed, and then we sped them up. I don't know. Real time, it was like, I think hours, and then condensed, it was 30 minutes. The video in the cell is motion activated. So then they had a recess, and they said that the audio portion of the video is excluded, um, over objection. It was a hearsay, objection, and it's limited to dates on the sheets from April to July. So and that's where we got today. So, uh, let's see if we got any other. Alright. So, I think I already put up Travis's question, right? Um, Thank you, Kathy. Love me some Bob. So glad he pulled you in the podcast and YouTube because you rock. I love your stories. We just have to, we'll just have to see how long I can continue to do this. I I wish it was, a much more profitable, uh, endeavor, but so critical darling. So he's been recorded 24/7, but no one knows the stand has watched him in his cell or watched his videos from the cell while he was in solitary, then why are they recording? She's like, "Yeah, sure." Like, everyone on the stand says, "Oh, I didn't watch it." Then why do they have it? Why do they have it? Good point. Um, bad juju. Also, confidentiality does not extend to events that involve abuse of children, which in this okay, so that's, also he was informed not to talk to her, however, she did plenty wrong. So, alright, I see what you're saying here, but that would be, like, events that no one knows about, So, like, if you've already been arrested for abusing a child, you you could have confidentiality. Not in this situation, you know, necessarily. I think that there were waivers that he was told it wasn't confidential. But if someone it's already been made aware that someone's accused of, harming a child, then they don't have to report it, right? It's already been reported. Um, and I'm not dealing with you know, the constitutionality of the statements, but he was, as you said, he was informed not to talk to her, at least so she says. So the prosecution seems to want to push that he was feigning illness. However, if he was feigning, they still decided to dose him with Haldol. And that's why I don't really get why they're saying whether he was faking or not, we had to dose him with Haldol. Like, to me, that makes no sense. Now, if what they were saying more clearly was because he made a conscious decision, not because he was crazy, but just because he wanted to look crazy, to not eat and not sleep and not drink water, he started really going crazy and we had to dose him. He was still really crazy in April, during the time frame that they were uh that these confessions took place. So, um Tier Talk also said he posted, and thank you, Tier Talk. He posted a quick video on his community board, generalized information of solitary confinement. He's going to do one more specific. I think we addressed this. Yes. Um, all right. So, here's another thing. Get all these objections about hearsay getting sustained on when it's the defense's case in chief. But as Jenny 33 points out, Google searches were not certified. It was a cop's narrative of what he thinks. He thinks Netflix searches for movies is a dark move. For God's sake, Netflix is available to kids. It's just ridiculous. I mean, I've never heard of such a thing. And I'll tell you what else I've never heard of is why in the hell is everyone talking about when Brad Weber clocked in and clocked out without certified records from uh, Subaru, without documents from Subaru, certified, verified, true, and accurate, kept in the normal course of business. We maintained this from this many years ago. I've heard nothing about that. But like I said, I don't know if some of the foundational stuff is not getting written down in Bob's notes because they're perfunctory, like, okay. But from what he was describing, like, no one knows, like, no, nothing, none of that happened, and they just started putting this stuff in, and same thing with the Google searches. I mean, it sounded like there were no so what happened with the Google searches, everybody, was there was because I was explaining it to Bob because he's like, "I couldn't find it in my notes." I said, "Because what happened was one day McClellan just said," and I think it was during I know it was during the first day, the last day of jury selection. They were bringing up, we've got these new, um, the defense gave us some new names in the discovery, and he brings up the fact that they've got some new records that deal with the search or something. And then I think it was um, brought up again at like in between witnesses. And sorry to get off track here, but DB Cooper, when he says Suber had handwritten time slips at that time, so saying like who can trust the time slip anyway? Um, but was it even something that was gotten from corporate from Subaru directly that they stored? Um, But that there was no actual Google search, because if the Google paperwork from Google came and said he conducted this search at this time, you wouldn't need the officer's report. An officer's report is hearsay, period. That's like everybody knows that. There's not a person who has walked a foot in a courtroom, well, let me take it back, who has had one criminal trial, bench trial, jury trial, whatever, or a hearing, uh, a trial, that does not know a police report is hearsay. Reports are never admissible. And you can't have one officer testifying to the report of another officer. Now, there are things you can do when officers work together and share information, but you would never be talking about his report. Did his report say this? Did his report say that? You would just say, did you, it's the collective knowledge doctrine. As part of the investigation, did you become aware that, you know, so and so interviewed so and so? So that's allowed. But what was said in the actual report, you can't talk about what's written in a report. You can't talk about that. You definitely can't get reports into evidence. Um, Subaru also rounded the time. So, I mean, these are things that would have come in if Subaru testified. These are my timesheets. This is what I mean, that's the way it's supposed to happen. Either they get in the record or they call the witness. And I think the defense could have argued that the record is not sufficient to just use like a certified record. They need to call someone from the corporation so that they can find out how the records are kept and how do they, things like that. Do they round up? Do they round down? Um, Indiana girl, there were specific rules the DOC was to follow when there's a diagnosis, and they weren't following them, claiming the safekeeping order prevented that. Yeah, that's bullshit. So, Trish, thank you very much for your generosity, catching up. Thank you, Allie and Bob, for taking times out of your lives and away from your family to keep us up to date on this. And for all intents and purposes, secret trial. For this all intents and purposes, secret trial conducted in this manner to shield her own conduct from being exposed. Yeah, that's Judge Gull. I mean, it's like, I don't know. I think the defense did, Linda Marks, use Walla's social media posts against her. I mean, I think it was just the fact that she made them, um, and she admitted that. If each juror can ask their own questions, it could be one juror's leaning towards guilt. Yeah, of course. It doesn't mean he's in trouble. You just know you've got, uh, and that could have been multiple questions from the same juror as well. So, I mean, we've heard the words, he was getting so Cleveland Rock's question is, does the jury know about the Haldol and its effects? They know about the Haldol. Uh, I mean, I think they can glean it because you've had questions on cross like, well, did you know he was taking Haldol and did you know he was taking mind-altering medications? So, but I suspect that the defense has a medical expert who's gonna get into that more. And I don't mean the defense calling a state witness like they've had to do. I mean an actual expert that the defense has hired. Does anyone know if Weber had any connection to Odinism or Brad Holder? He lived right at the end of the Monon Bridge. The girls clothed had a line of water like they crossed, possibly to his house. I mean, definitely possibly to his house and possibly transported in his giant van. I mean, cops were looking for a van. Why in the hell were they looking for a van to begin with? If if that's, you know, if that's what was in the discovery. I mean, I don't know, but it's highly suspicious. Also the title of a My Morning Jacket song. Um, ACAB, true crime, nothing is confidential in prison as a psychologist, period. Correct. Different rules and standards. Correct. Well, yeah, ethical or not as far as that, correct, but all the other things she's doing, that's where the question is. But I don't know what people were saying in the chat. But yeah, when you're in prison, you know, nothing is confidential. I'm just saying if someone in jail has in a jail setting, okay, pretrial, has a mental health illness, I have never, ever seen them get treatment or therapy because it's a prison. They've got therapists there. So, I mean, it could be just as innocent as that, but and I don't know, Brandon, thank you for your generosity, what the 2012 psych hospitalization was for, but I'm sure we're going to, it might have been for suicide. I don't know if that's what SI stands for. Might have been for depressive disorder. I'm not sure. And Emma says, I don't understand why the state can testify to evidence that they don't know is fact. It has been a theme saying the van was not something he would know, but they didn't check discovery for it. And again, I'm going to say this again. Barb McDonald keeps saying that it was well known in the community and amongst the police that they were, it was assumed that Brad Weber, when he came home much later in time than he's now saying, might have interrupted, scared away the perpetrator, but so and if you're going to accept that, like, the guards, like, the people are telling him, information that they know. These were things being discussed in on social media all over the place. So, if the guards are giving him his words, let's think about his words. Okay, let's think about his words. I did something with the gun. He can't even come up what that something might be to make the cartridge fall out on the ground. So I did something to the gun to make the cartridge fall out. Well, of course someone would tell him you did something with the gun on the bridge, right? Because it's the state's theory and what was released that the girls said gun on the bridge. So that's why Richard Downs like, and then I did something with the gun on the bridge, right? He doesn't even know what he did with it. He did something with the gun on the bridge. And they've all been saying that the person got interrupted. So these are all things that someone could be saying to him, you know? Like they could be telling him, like I'm hearing like just, if you do this, either your situation gets better or it's better for your family, but they're still going to love you even if you say you did this. They're still going to love you. And so he was willing to say it if he could believe that his family would still love him if they thought he did it and if he said he did it. Um, I mean, there's just so many things as far as I see it. But then the other thing that he said was, um, oh, okay, what is this? Lying in wait. Okay, that is a term of art police use. That is a term of art lawyers use. What son of a bitch in Delphi, Indiana, describes waiting and watching as lying in wait. That's what he said, the words, lying in wait is what he said. Like, the new stuff that the guy testified to yesterday, whatever that last cop was, about what Richard Allen allegedly said to Walla based on what Walla wrote in her report, has him saying he was following the girls and lying in wait, you know, instead of just waiting. Well, I was waiting for someone to pass by. I mean, that's what a normal person's going to say. They're not going to say they were lying in wait. Um, I did something with the gun on the bridge because no one knows what was done with the gun. He can't even come up with what is done. You know, Criminality did a lot of work on the white van long ago. And this doctor mentioned your show, but Criminality as well as what she watched. And I don't know if Bob ever talked about the van. I honestly, I just don't know. But I have heard that Teresa has. So she's watching that, like, and she's not the only one. You don't think the guards are watching this stuff? The guards with their Odinism patches and, you know, everybody is watching this, you know? And there's no cameras, so they could have been audio on the cameras, so they could have been saying whatever to him on the other side of that. Everybody knew they needed a confession. That is, like, you guys have to be listening because we need this guy to confess. So if you don't think they're feeding him information, we know that you followed those girls on the bridge and you did something with your gun and that's why your bullet fell out and you were interrupted by a van. Like that is stuff that people could have said to him, you know. Um it just doesn't make sense. It doesn't make sense for the way he's saying it. That he crossed, that they went down, he got interrupted, he was gonna sexually assault them, went right there on the side of the thing, but they wore their clothes across the creek because of the lines, so you weren't going to because you didn't take the clothes off till later. So if you were so scared, why'd you take the clothes off? Why is there a undressed child there an hour and a half after you're allegedly interrupted? It doesn't make sense. It doesn't make sense. And guys, don't forget, there's a lot of people in here and we're trying to decide if it's going to keep being worth it to do these afternoon sessions. So I really appreciate the likes, the shares. Subscribing is free. It gives you notifications of, when we go live. So here's the other thing, give you guys some updates about what Bob's going to be doing today. He's doing the drone. Okay, check Cash Apps, etc. Allie. I don't think I can check Cash App, but I can check Venmo. So um and we like seriously appreciate Cash Apps, Venmo, all that because then the man's not getting his piece. So, um, I don't see anything new from Venmo, and I thought I could check PayPal. I thought I decided I could check PayPal. Let's see. But now I see now I do oh, no, that's me paying someone. Hmm. Okay, I found one. So weird. Lynn M, thank you very much for your generosity, all your amazing work to make sure this case doesn't stay in the dark. Thank you, appreciate it very much. Um, Wanda L, thank you for your generosity. We appreciate all your work, Allie and Bob. Hoping tomorrow is epic. I wish I could be there in court to see the defense. Well, there's a lot. I don't know why I didn't see it. It's so weird. I put in PayPal, all these popped up. I put in Venmo, none of them popped up. Megan P. I mentioned this the other day, the Halloween fund, but thanks again. Thomas M, appreciate what you're doing. You and your wife, we appreciate your generosity. Laura F with $100. Allie, you are rocking the lunch lives. Love the way you break down the law. Probably pretty awesome too. I think I read that before, but that's fine. Read it again. Um, there was an Alicia S. And I don't know if I mentioned this, and it was just a payment. So thank you for your generosity. $25, very generous. Um, I think we got Carrie W, who was also generous. Oh boy, notes incoming. I don't know about this. I I don't know about this, but I'm gonna keep going. You guys are gonna have to let me know, but I do think all right, here's what we have to do, all right? If we get, because it sounds like we only have 827 likes, so clearly you guys do not like this or not enough of you. So Bob just sent me more notes. What my plan is with the notes is I like now to take some time to read them before I come on so that I have a more kind of firm, um understanding. But what I was starting to say is Bob's going to so get those likes up if you want to get more. But Bob is gonna do the drone thing today. And he's going with someone from the area as well, who knows the area, who knows the people, who's, can tell him where was there an old building somewhere? Because again, what Richard Allen said, he didn't say I parked where the old building was. He said he parked by an old building, which would mean a building that was still there, not something that was taken down. Um, so someone that can do all that. And he said the leaves have fallen. So now we are getting, and it's a clear, nice day. So we are getting very, very similar conditions to February of 2017. So, uh, so that's huge. Let's see what you guys are saying. All right. You guys more just talking to each other. Um, Kathy Young Joy Young says, "Keep Allie on." Thanks, Kathy. And thank you, Kathy Bellman, for the super sticker. Um, all right, so notes are incoming. Um, I'm gonna read the notes and then decide if we're gonna uh, come back at you this afternoon. Uh, see if we have any other questions here. Ah, got the notes. Got the notes. All right, you guys are we're slowly increasing the likes. So let me just glance at them real quick. Let's see what we got. How many pages they are. Wow, it's a lot of downloading going on. A lot of downloading. Okay. All right. They're 11. All right. So we've got a Brad Health who came on. He's about 70-year-old. He lives outside of Delphi. So, um, like I said, I'm going to want to read these before I start going in, but I'm just going to tell you who testified. Um, so he's the fourth witness. I'm going to give Bob a call and get some of his Huh. So he's gonna talk about what vehicles were parked by the, CPS lot. Then you got David McCain. He's lived there for, you know, 30 years. He's done a lot of community activity. He was out there 2 to 4, so we'll get into what he saw and didn't see. Wow, alright. And then witness next witness was a Daryl Sturrett. He's an uh, he was a firefighter and a fire chief. Alright, well, it looks like we got a lot of interesting stuff so far, but like I said, I don't wanna torture you guys going through this without reading it first. So I think what we should do is end this stream. Let me uh let me talk to Bob about and look through this, and I will come back at you guys. Let's see if you guys really want it. All right. Well, we've got some additional likes. So that's going to be the plan. I'll talk to Bob. I'll read the notes. Come right back at you. Oh, um, unless Dizzy, you think we should do something different? You can put a little comment over here, or let's go down. Jeez, comments are coming fast and heavy. No, please don't leave me. Should I let you guys keep talking while I do this? Or yeah, we'll just no, it's a good plan, Allie. Okay, Dizzy. So we'll do that and we'll put up a new live. Don't worry, you guys can hop in there early and talk all you want. Um, it'll get set up uh momentarily and I'll read you all the notes because it looks like some interesting stuff happened. Catch you soon.